Well, hello, everybody, and welcome to the Community Association Trends webinar. I'm Marketing Manager Sherry Branson, and today we're going to talk about claim trends in the community association industry. I'm joined by Kevin Davis, the president of Kevin Davis Insurance. Hi, Kevin.
Hey, how you doing?
Doing well, thank you. Doing well.
Hmm.
Kevin's in Los Angeles, and I'm on the East Coast in Florida, and we have a very special guest today. We have Elizabeth Hoff, Claim Counsel from Travelers Insurance. Hi, Liz.
Hi, good afternoon, Sherry. How are you?
I'm doing well, thank you. And Liz,
Great.
thank you for joining us for today's webinar. We're going to talk about claim trends that are happening in the industry that we all work in. And can you tell everybody a little bit of something about yourself?
Sure. So, good afternoon to everybody, or good morning to the West Coast folks. My name is Elizabeth Hoff. I am claim counsel with Travelers Insurance, as the slide says. I've been with Travelers for a couple of years now, and I specialize exclusively in condominium and homeowners association claims. And prior to coming to Travelers, I was in private practice as an attorney, litigating insurance coverage.
Great, fantastic. Thank you so much for joining us today. And thank you everybody for being here. I did want to take a second to show you a disclaimer that we have on the screen. Please take a minute to read through the disclaimer. And I also wanted to mention that we record all of our webinars and we put them on our website, which is kdisonline.com. And if you'd like the PowerPoint from today's presentation, please send me an email, which is sherry.branson@amwins.com. I'm happy to send you the PowerPoint, and you can listen to the recording at your leisure on our website later on. Okay, so that's the disclaimer, and welcome everybody. And we're going to do a very quick Q&A at the end. If you have any general questions about what we're going over today, feel free to type your questions into the Q&A box. And Kevin, now what are we going to talk about today? What's our goal? What are we trying to accomplish?
Yeah, thanks a lot, Sherry. Today we're talking about something really, we love talking about, and that is D&O claims trends that we're seeing, especially the ones that impacting community association, because that's our specialty. But today we have a special, and I like the fact that we have actually somebody who handles the claims, somebody who looks at the claims, see the claims. She gets to deny the claims or accept the claims or issue a reservation and rights letter. That's her job. So we're going to hear from her point of view in terms of what she sees, what she's concerned about. We're going to have a great time at it. We're going to have a really good time at it. And again, if you got any questions, put them in the questions box and let's get started, right? Um, Liz, it's interesting when we talk about the claims that's coming in. I think the most important thing first we do is examine what constitutes a claim. What is a claim? And you can see by the slide here, and this is the most important part because just this first line, a written demand for monetary or non-monetary relief is critical. Probably the most important line there is in here. And the reason why is because whenever you have a liability claim, any type of liability claim, and you read the insuring agreement, it always says a suit for damages. There has to be damages. If there's no damages, there is no claim. Here, in the world we live in, the community association world, we have monetary damages and non-monetary damages. So Liz, why don't you talk right about what the difference between those two are real fast for me?
Sure. So sometimes you'll get a demand in that's even pre-suit, for example, and they'll say, I'm demanding $5,000 to resolve whatever issue I have. But because we're dealing with community associations, homeowners associations, there's usually some type of non-monetary relief. So whether it is, I demand that you review the application that I submitted to the Architectural Review Board, or it's some type of relief where there isn't a monetary component, but they are still asking for something or demanding something, I should say, from the insured.
And I would say most of the claims that we see are for non-monetary relief because they're more emotionally driven than financial driven. Do you see the same thing?
We see usually a combination of the two. I would say it's very um it would be a one-off for us to see only a monetary demand. Normally, the monetary demands are accompanied by some type of request for or demand for non-monetary relief.
Mm-hmm. And this is why it's so important because if you have a D&O policy that doesn't say monetary and non-monetary relief, be careful because again, we're going to see claims where somebody's upset because you towed their car away, or you didn't paint the right house the right color, or you have a pet. And they'll ask for damages. They want to make sure that the judge out there says that you're right, the board's incompetent and the board has no idea what they're doing, and you're right. And that's what they really want. Isn't that what, that's basically the demand they want, right?
Yes, very often that's what we see.
Now, it's interesting. Now, when we look at this 4 areas here for what constitute a claim. Now, we have something here called criminal proceeding commenced by an indictment. So basically, let me ask you this question, because it's a question I always wanted to ask a claims person. So basically now, all of a sudden, and I've seen this years ago where a board was held criminally negligent by not installing window guards for their children, and the children fell out. So how do you would defend something like that, or how would you, have you ever seen, I guess, a criminal proceeding commenced by an indictment?
So I actually have never seen anything that falls within a criminal proceeding that would fall within the definition of a claim under the policy. We've had things come close, but nothing that's ever actually constituted a claim.
Like what came close?
So we had one criminal complaint that was filed against a board member for engaging in a verbal altercation with a member of the association. But there wasn't an indictment against him. There was just the initial filing of charges, so it wasn't enough to rise to the level of a claim. And unfortunately, the matter was dismissed before it ever rose to that level.
No, okay, interesting. So they got into a fight and there was an indictment. That would be a whole different. Well, anyway, that's interesting.
Yes.
Okay, so the other 2 areas here, civil proceeding, we understand a formal or administrative or regulatory proceeding against insured. That's kind of like the Fair Housing Act, American Disabilities Act, right?
Yes, we see a significant number of claims that are filed in state fair housing or human rights division agencies, as well as some federal agencies like the EEOC as well.
Now, this is what constitutes a claim. So in order for you to submit a claim to Travelers on a policy, you have to be one of these 4 things. Now, one of the things that we run into is that now you understand what a claim is. The problem is timely reporting of a claim. That is the one thing that we talk about more than anything else, is timely reporting of a claim. Can you talk about, Liz, why that's so important?
Sure. So the policies that we issue, with the exception of New York, are claims made and reported policies. So they have very strict reporting deadlines, which requires an insured to report a claim within 60 days of the end of a policy period, for the policy period within which the claim was made. And so the sooner you become aware of a claim, it's critical that you report it to Travelers as soon as possible so that you don't run afoul of these notice requirements.
And when you run afoul, what happens?
The claim may be denied for untimely reporting.
Exactly. That's the key thing.
Yes. And if there's a question, the policy also provides for reporting a notice of what's called a potential claim under the policy. And so that there bookmarks the policy and lets us know, hey, this may turn into a claim. And that way you ensure that you are not running afoul of these reporting requirements.
All right, great. Thanks, Liz. These are the questions that I get to ask all the time in terms of, what constitutes a claim and what happens if we don't report that claim timely. And it is probably one of the top 3 areas of why a claim gets denied. In fact, it's probably the number 1 area I get a phone call for saying, you denied my claim. Why you denied my claim? And I said, well, the claim occurred. You didn't report it in a timely manner. Yeah, but there was no lawsuit. No, a claim is a written demand for monetary and non-monetary relief. It doesn't say it is a lawsuit. So hopefully they got it now, right? What do you think, Liz?
Yes, I think so.
Okay, so let's go into the trends now. So we got 3 trends we're going to talk about. The first one is discrimination. And to me, when we talk about discrimination, this is to me a new trend that's developed, because since post-COVID world, we're now sitting at home. Like right now it's 11 o'clock in the morning here, it's 2 o'clock where you guys are at. And I'm sitting in my home, I'm looking at my window there, and I'm in my backyard, so I'm not worried about it. But I'm looking at my backyard and see that, oh man, the trees need to be trimmed and, things need to be done. But then all of a sudden I see a sign in the window that I don't like, that I find offensive to me. Okay. And now I'm going to have to go to the board and make a complaint against them because I feel like I've been discriminated against because that 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 sign there really messes my sensibility. So is that do you see those kind of claims?
We do. We see, and as you said, post-COVID, we really have seen an increase in discrimination claims. And these are broad claims too. They can range anything from somebody seeing something where, it offends them, as you said, or people that want emotional support animals that are being denied the emotional support animals for one reason or another. And then you also see them in the employment context as well, be it, sexual discrimination, racial discrimination, that sort.
Now, what about now? We historically seen Fair Housing Act claims covered under it. We've never seen much ADA type claims, but you see a rise in ADA also?
Yes,
American
specifically in New York.
Disabilities Act, yes.
Yeah, specifically in New York City, we're seeing a decent increase in those claims as well. Some of them are what we would call tester cases, where it's serial plaintiffs that seem to be looking for ADA violations.
Yeah, I remember one guy, and I forgot his name, and I probably shouldn't say his name anyway if I did remember it. But he'd have a wheelchair, and he would go in, and they weren't had the proper, the proper distance or the proper way to the accessibility that he would file a claim. He would do like file class action. He would go to all the associations there. So we have these serial people again doing the same trick again, I guess, huh?
Yes.
Yeah. And they holding out just for what, the dollars and make it go away, or they
For
actually
the
want
most part.
remedy.
For the most part, usually there has to be some type of, again, as we had talked about earlier, non-monetary resolution, be it, installing a uh, movable step that allows access for wheelchair bound individuals, or other modifications that are temporary but also can assist with correcting the ADA violation, and then some type of monetary component as well.
Now we won't pay to fix the the stairs or anything like that, right? That's excluded,
Correct.
right?
That is
Okay.
excluded under the policy. Yes.
Okay. Now, what about discrimination damages? So all of a sudden, there's a lawsuit out there. Now there's large award, because I've been discriminated against. I was mistreated. They towed my car away, and I'm African American, and they didn't tow away somebody who was not African American. So now I'm going to the bank with millions of dollars. Would you pay a judgment on a discrimination case?
So the answer really is, it depends. Obviously, the policy has exclusions for emotional distress damages, which can be a significant component of these discrimination claims. So really, it's going to depend on how the verdict comes down, and how it's portioned out, if you will.
Okay. All right, good. So, okay. So now, is there a certain part of the country where you're seeing more discrimination claims than anywhere else? Is it is it across the board? Because one thing is that I'm under the impression that this post-COVID world, yeah, people are just, we live in a 50-50 world right now, where no matter where association you live in, you're gonna have people who are not gonna like any decisions I make and really gonna be against anything. Have you seen like any trends or anything in terms of, you see a lot more like in Florida versus New York or Texas or California?
I would say we're really seeing them all over. I mean, we're definitely seeing them in the Northeast, but obviously there's a very large concentration of people in the states like New York and New Jersey. And then there's obviously a significant number of community associations in Florida and in California. So while we are seeing obviously an increase in those states, we are seeing them across the board, all over the country. And I think there is some semblance of, um, people being concerned with how their community associations are handling things. And so I do think that accounts for part of the increase.
Okay. And one thing you have to remember is that discrimination is excluded on a lot of policies out there. So historically, it always was because it's illegal to discriminate. However, we can't, we're not going to, when we first put the policy together, we didn't want to accuse you of doing something illegal. So we provided a defense, and based on, the determination at the end, judgments or settlements could be paid or may not be paid. So, so thank you. I like that one. All right, let's go to the next one. Something new that we've never talked about before in all the years we've been doing this. And let's talk about now something called pro se claims. All right, what is a pro se claim?
Sure. So what we're seeing an increase of is claims that are brought by self-represented individuals who have not received, or excuse me, not retained the services of an attorney. We see this a lot at the agency level, where the process has almost been modified in order to make it easier and more accessible for individuals to file these claims. So whether it's with the Fair Housing Act claims or the Division of Human Rights, they'll go ahead and file a claim without the services of an attorney. But we are seeing an increase in these claims, in state and federal court, as well as the courts become more accessible to these individual litigants.
Yeah, and it's interesting because we've seen them in the past, and I hated these things because if you don't have a lawyer, you're not paying anybody. So if you're not paying anybody, you have all the time in the world for somebody to hear all your stories about how bad and how incompetent the board of directors are. And you should now, are these monetary kind of damages, or is it just, again, it goes back to I want to park in my spot and then he doesn't let me park in my spot, so I'm going to just keep this thing in court until the judge determines, or you actually want money? Which one have you seen?
We're really seeing both. And primarily it's because when you're working with, or when the claimant is not an attorney, they're going to ask for everything under the sun, because sometimes they don't quite understand what is limited by the claims that they're alleging. And so some people, it's they want money and they want a lot of money, and then other people, it's they want certain changes made to the association, or they want, as Kevin said, their parking spot or their house painted a certain color, things of that sort.
Yeah, so this is a challenging one because I do remember one of our largest claims we've had. It was a list of things that everything the board has done wrong. They breached their fiduciary duty because they didn't enforce the documents right. They breached their fiduciary duty because they didn't collect assessments, that they didn't have reserve studies done. I mean, it was like a long list of these things. Do the judge give them leeway because there's no lawyer because there's no lawyer present? Do they have special treatment, or what happens in those situations?
Yeah, and I don't know if I'd term it as special treatment, but I would certainly agree with you that the judges do give these self-represented litigants plenty of leeway, because obviously they don't have the same formal training that lawyers do. They're not barred with the state's bar association, so they're not subject to the same rules. And so courts will give these people, sometimes 1, 2, 3, 4, 5 chances to get either a pleading right or to extend a pleading deadline when they otherwise wouldn't extend that same courtesy to a practicing lawyer.
Okay, all right. Yeah, this is one of those things where again, I've seen some in the past, but you see a rise in them. And to me, when I see a rise in something, it goes back to where we at today. In other words, we want to feel that we're being heard. We want to feel that we're not being mistreated. And some of these pro se people are the people that in this living associations that believe that they just haven't been treated fairly, that their reputation's on the line, that they suffered because I haven't got the respect that I demanded, that I deserve, and so they go after the board and they go after everybody in the community. And do you agree with that? Is that where the thing kind of rise from?
Absolutely. And sometimes it's just they want to be heard. They want their day in court. We've had definitely situations where you get to mediation and it's really just the individual just wants to be heard. They want somebody to hear what they feel, how they feel they've been wronged. And once they kind of are able to speak their piece, sometimes these claims are able to be resolved fairly quickly, because that's really what they were looking for. So
yeah. And that's interesting about these pro se claims, is that you probably can get them out of the way by doing some form of mediation, because again, a lot of times their damages is just their hurt feelings because they couldn't park, or they couldn't have their pet, or the dog was barking. One of the things about you talked about pets, you got these post-COVID pets that are now home barking all day long while the person who lived there is back at work. So yeah. Okay. All right. So what's our third one we have here? Third one, breach of contract. Now, this is interesting. For those who don't understand, is that when you had historically, breach of contract claims were uninsurable. You could not insure a breach of contract claim. And the reason why, because the associations want to enter into a contract, and then they have to fulfill the contract. And if you don't fulfill the contract, there are penalties, and it's not the cost of it's just the cost of doing business. It's not something that should be insurable. However, when we first put this program together, you have boards of directors that are not knowledgeable, that are uneducated, So they historically have get into contracts with landscapers or roofers or property managers, and then they end up just canceling the contract, not understanding the full effect of it. So what we did is come in and started defending these things, and it's now if it's rising again, is that what you're seeing? You're starting to see a rise in these breach of contract claims?
We are, yes, and you know, who knows what it's coming from, right? But we have definitely are seeing a rise in claims where an association has retained the services of a vendor, as you mentioned, Kevin, something like a landscaper, snowplow contractor, things of that sort, where they've terminated the contract for one reason or another, be it that the service provider was not providing service up to everybody's expectations, or they weren't showing up, and then they're failing to pay invoices that have been accrued, or they're just failing to pay out the remainder of the contract, depending on the terms. And so we're seeing definitely an increase in those claims.
Okay. I hate those kind of claims. Now, but we don't pay judgments on them, right?
Correct. We
Okay.
pay defense costs under the policy, but there is no coverage, no indemnity coverage for
No
any
indemnity coverage.
judgments entered. Yep.
Okay, all right, good. So again, the three things we've talked about, discrimination, these pro se claims, and the breach of contract claims. There are trends that we ask, we go every year, we go back to Travelers and say, what are the trends? What are you seeing in there? And these three things are excluded under most D&O contracts. So whoever's listening on here, we got 100 people registered. Write that down to make sure that your policy do not exclude discrimination, breach of contract, pro se claims. Again, it depends on type of claims. We're talking about the ones that are non-monetary. Okay, if you have a non-monetary pro se claim, and I would suspect a lot of them are, because if all they want to do is be heard, if they don't want damages, then a lot of times you'll be no defense costs for these things. And we talk about pro se claims, or we talk about non-monetary claims, you're talking about primarily defense costs. The thousands of dollars just to be able to park your car where you want to park it in visitors parking because you believe you had the right to park in visitors parking, or you have your dog or whatever it is. To support animal. I mean, that's something that's been a problem for years and will always be a problem, because I want my little dog and you shouldn't be able to stop me no matter what, because I want to be heard. Right?
And they're very emotional, especially with the emotional support animals, because they're usually, they're pets as well. And so they can, yes, those claims certainly are very emotional.
Okay. All right. So let's wrap this up. So one thing that we can do to help you out, okay, is a couple things. Number one, we have a risk management hotline. If you have a traveler's policy, okay, understand you have this hotline available. Now, Liz, I don't put words in your mouth. So why don't you tell us where your responsibility lies?
Sure.
Yes.
So I am a claim handler with Travelers, as I said at the top of the webinar. And so to the extent you have questions specifically about a claim that's been tendered to Travelers or notice a potential claim, you should be receiving correspondence from Travelers that lets you know who the claim professional is that's been assigned to it, be it myself or one of my colleagues. Feel free to give us a call once you get that letter, just to either introduce yourself, or if you have any questions about the claim, we are your direct contact for specific questions that you may have about any claim that is with Travelers.
Good. Now here's a question that I always get. So when you get their a claim comes in and you respond back, usually you have like three responses: is that you accept coverage, you deny coverage, or you reserve the right. Is that the three things you normally? Is there a fourth or fifth one, or those are usually the three?
They're usually the three with some shades of gray. The majority of the time, I would say it's either we are accepting under reservation of rights, or the claim is denied. But then, as I talked about, sometimes something comes in where we take a look at it and we realize that, hey, this actually isn't a claim yet, so we're going to monitor the claim and consider this a notice of potential claim. And then there's other circumstances where if you ever receive something and we send you a letter that's saying it's an insufficient notice of potential claim, that usually just means, right now it's not even enough to put Travelers on notice of what may be coming down the pipe. So you need to give us additional information.
Okay. And once they give you additional information, even though it might be a year later, they may have switched carriers, you still are being notified of this claim, so that a future time you would be providing coverage, or you could be providing coverage, right?
Yes, as long as it qualifies as a notice of potential claim. If it's something where it's an insufficient notice, that's not enough to bookmark the policy, as I had said earlier. So it's critical that you provide us with enough information in order for us to determine that it is at least a notice of potential claim.
All right, perfect. And one more thing I'm gonna throw out there is that now all of a sudden we know that we got to submit in a timely manner. Okay, what are like maybe like one or two reasons why you would send a declination to a D&O claim?
Sure. So the two biggest policy exclusions that we see apply are the property damage exclusion and the bodily injury exclusion. And the property damage exclusion, both of these are fairly self-explanatory. Basically, the policy doesn't provide coverage for any claim that's based upon or arising out of property damage, including the failure to repair or maintain property damage. So we see a decent amount of those claims. And typically what we advise the insured to do is to speak with their general liability carrier. And the same goes for a bodily injury claim. The policy doesn't provide any coverage for bodily injury, including emotional distress. And again, that's a claim that we would typically advise the agent as well as their insureds to tender to their general liability carriers.
Okay, any other exclusion out there you want to throw out that sometimes pop in, or those are like the two big ones?
I think those are the two major ones. As we talked about though at the opening, it's really critical that we receive a claim, a timely reporting of a claim. That's also something where insureds can run into trouble if they just receive something and set on that and don't report it in a timely manner, or if they receive something and just didn't, they should be able to realize, especially after attending this webinar, that just because something is not in litigation yet does not mean that it's not a claim under the policy.
Okay, great. That's good. That's good. All right. I think that's it. Any closing statements? I think you just had a couple good closing statements. Let's see. Do we got any questions out there? Hey, Sherry, you want to come back in?
Yes, Kevin, we do have one question, and I did want to bring up a couple of other common claims and just ask Liz if she's seeing those as well. Breach of fiduciary duty and short-term rentals are those areas you're also seeing claims in. We've talked about those in past webinars, so I was wondering if that's still an issue.
Yes, absolutely. Breach of fiduciary duty claims are very standard claims that we see in almost every complaint that comes in, that along with breach of the governing documents or the CC&Rs or the declaration, things of that sort. And then, yeah, short-term rentals continue to be a claim that we see a lot of, especially as people, are buying investment properties and looking for ways to generate revenue off those properties.
Mm-hmm. Excellent. Thank you. Thank you. And Kevin, we have another question that would you like to, I'll read it.
This first one's an interesting one. Okay. Yeah. It says, if the claim doesn't come close to the indictment, does that mean the policy just pay for defense for that claim, or there's no coverage? Well, basically is this, I will say this, is that this is a general liability. In other words, it's a bodily injury type claim. So we would send it without an indictment, without any criminal activity. It's just a regular bodily injury claim that you report to the GL carrier. So yeah, and so that wouldn't. This doesn't. When we talk about the indictment part, that means it's a criminal complaint. And again, the perfect example was the window guards in New York, where they failed to properly install window guards, and now it's a criminal indictment against the board of directors. Now that happened years ago. I have not seen anything since then. But again, you want to make sure that So anyway, you had another question? That was the only one?
That was the only one, yeah. Okay. If anybody thinks of any other questions later on, feel free to email me your questions. My email again is sherry.branson@amwins.com. Feel free to send me your questions. I'll give you a call or email you back, or Kevin will call you or email you back. And again, we record our webinars, so you can listen to this webinar again on our website, which is kdisonline.com. And if you'd like a copy of the slides, send me an email as well, sherry.branson@amwins, and I'm happy to email you the slides. So thank you for great information today. Thank you so much. Liz, it was a pleasure having you.
Thank you for having me.
Thanks a lot, Liz.
Thank you all.
All right, listen, take care of yourself. Tomorrow is Veterans Day, right?
Yes.
So let's kind of give a shout out to all the veterans out there and thank them for the job they've done. They have a tough job, especially today with all the things going on. So we appreciate the veterans. So thanks a lot.
Thank you.
Thank you. Yes, happy Veterans Day, and have a great rest of the day, and a happy and safe Thanksgiving as well, because we won't see you until after Thanksgiving. So take care, everybody.
Yes, great. Thank you. Take care.